Can a reasonable mistake of law or a police officer's misunderstanding of a traffic statute still lead to a valid stop? Heien v. North Carolina. In the case of Heien v. North Carolina, Sergeant Darisse pulled over a car in North Carolina because one of its brake lights was out. The driver was Maynor Vasquez, and the owner of the car, Nicholas Heien, was asleep in the back. After obtaining consent to search the car, Darisse found a sandwich bag containing cocaine. Heien was charged with attempted drug trafficking. However, it was later discovered that North Carolina law only required one working brake light, making the initial stop based on a misunderstanding of the law. The central question before the Supreme Court was whether a police officer's reasonable mistake of law could provide the individualized suspicion required by the Fourth Amendment to justify a traffic stop. The court defined reasonable as a mistake that is objectively understandable, given the specific circumstances and the complexity or ambiguity of the relevant law. Essentially, the court had to decide if an officer's misunderstanding of the law could still lead to a lawful search and seizure. The Supreme Court, in an 8-1 decision, ruled that a police officer's reasonable mistake of law can provide the individualized suspicion required to uphold a search or seizure under the Fourth Amendment. The court reasoned that the Fourth Amendment allows for some mistakes on the part of government officials, provided those mistakes are reasonable according to the court's definition. Therefore, the evidence obtained from the search was admissible, and Heien's conviction was upheld. This decision clarified that a police officer's reasonable misunderstanding of the law, as defined by the court, could still result in a lawful stop and subsequent search or seizure.